subject to no law.
Thank you. Let me ask you all to refresh my recollection or to give me some information. I believe that we've only had one other special counsel, and that was Mr. Danforth in Waco under the regulations. And we had two independent counsels, Mr. Jaworski, he was a successor to another independent counsel, and Mr. Starr. Did any of those three individuals give opinions of violations of the law in their reports, or do they make the reports, submit them to Congress, and let Congress make decisions?
Roadmap that the grand jury provided to this committee in the context of that investigation, because it is so important for Congress as a co-equal branch to uphold our Constitution and ensure accountability here.
And same thing for Kenneth Starr. He didn't recommend this is a violation, that's a violation, I would indict or I wouldn't indict. He just gave the report to Congress, did he not? So this is really strange. It's the first time in maybe the history of the country in a special counsel or independent counsel that the Attorney General has jumped in the breach and given his opinion of what the report said. It's never happened. Okay, let me ask you this. Is it possible that there was a counterintelligence portion to the Mueller investigation and that wouldn't have been part of conspiracy, but something in there about counterintelligence that might have shown that the president was compromised by his holdings of properties in foreign countries, or his desire to have a property in a foreign country, or loans that were made to him, or monies that were laundered through a bank to him, and that possibly those compromised him, and we could have a president that the report could show is under the influence or could be under the influence of the Russians, and yet it still wouldn't amount to a conspiracy? Is that not possible? Ms. Frederickson, would that be something you think might be could be in the Mueller report?
Well, it might be. Obviously, I haven't seen the Mueller report, and there may be parts of it that involve national intelligence that I would never see. It's my top secret clearance has expired. But certainly an important question, and again, a reason why Congress needs to get that report, because you can certainly examine all of that.
And is it possible that there's something in there that might amount to a cover-up of knowledge of what the Russians were doing, which would not amount to a conspiracy? Like if the Trump children, or one of the children, knew that the Trump campaign was, what the Russians were doing, but didn't say, we're going to do this for it, there's no quid pro quo, but they knew about it, and maybe they even discussed, well, we'd sure like to have sanctions lifted at some time. That wouldn't be a conspiracy, would it? How far would they have to go to make that a conspiracy? And maybe they wouldn't want it to be known if it was less than a conspiracy, but maybe a cover-up of some information.
I really don't. I can't comment on what might be in the national intelligence portion of the Mueller memo. But again, I can only say that that's why it's so vital that this body examine that information. There certainly are many aspects of certainly much that we've seen reported about relationships that have to do with financial holdings, with property, with the Trump Tower in Moscow, with a variety of other issues that may not have been part of a conspiracy, may not have been the government necessarily, but may be a reason why there could have been a cover-up. But again, I can't really speculate, but I think it's important for you, because many people are thinking of those, asking those questions of themselves, that for them to be definitively answered, it comes to Congress to do that.
You made a point in your opening statement to say that the Barr 19-page memo was devoid of legal support, right? But if it had a lot of political support, wouldn't that trump the legal support?
Right. Well, I think Professor Kent, he used the word extreme. I used the word in my oral testimony just now of fringe, but I think you can find a few people who will endorse it, but it's certainly, it's a very interesting contrast between some of the things that Mr. Barr said in his testimony before the Senate Judiciary Committee to what he said in the memo when he was a private citizen, auditioning for a different kind of job with the president. So certainly it has some political force behind it.
Coming back to pardons to close this hearing out, there was a governor of Tennessee, I don't know if any of y'all have heard of him, Leonard Ray Blanton. Anybody heard of Leonard Ray Blanton? Former member of the House, governor of Tennessee from 1974 when he was elected, leaving Congress after 8 years, and served from 75 to 79. Leonard Ray Blanton, at the last minute, right before he was leaving office, the FBI found out he was going to issue a lot of pardons to a lot of people for money. So, the lieutenant governor of the state, John Wilder, the speaker of the state, Ed McWhorter, jumped into action with the winner of the 1978 election, now United States Senator Lamar Alexander, and swore him into office about 48 hours or 24 hours right at the last minute early so that Governor Blanton couldn't issue those pardons, and he didn't, and Senator Alexander became, then Mr. Alexander became Governor Alexander. But by issuing pardons at the last minute, but for somebody having knowledge of it and stepping into the breach, there is no remedy. Impeachment is not a remedy. So I find Mr. Mason's perspective better than Mr. Madison's because Mr. Madison was wrong to say impeachment is the answer. Impeachment's tough. And impeachment can't do anything for somebody who issues pardons at the last minute. And I just remember the Clinton administration, almost all the pardons were at the last minute. Obama, as I've said, I urged President Obama for 3 or 4 years to be issuing commutations. And I had confirmation from people who were in the office, his attorneys in the office who worked on that they had gone so slow and the process was terribly slow and they didn't get the offices geared up and they lost people, they lost their pardon attorney, I think quit. And I forget the lady's name that worked over there in the White House counsel's office, but if he issued 1,700 commutations, I again say that was about 7,000 too few. And it was 0.3, not 3%, but 0.3% that Mr. Johnson said had violated some portion of the law, 4 people out of 1,700. Obama did pretty good in his thorough examination. He didn't do good enough for the rest of them. I think we need to amend the pardon power. I recommended it back in 1977 when I was a Constitutional Convention of Tennessee vice president, or the vice president of the Constitutional Convention, and we had the pardon power before us because I knew what Ray Blanton was doing and it had come up, and recommended that we change the pardon power and give it, say, if 4 of 5 of our Supreme Court justices looked at it and didn't think it was in the interest of justice, it wouldn't go into effect. Now, the justices didn't want to touch it, and it didn't get anywhere, but it was a way to put some kind of a limit on the governor's pardon power by having the court look at it. Here, we proposed limiting it to certain close folk. But there should be something, and I hope you all would give it a little thought and submit to me, if you would, any thoughts you have on how we should amend the pardon power or recommend it. Not easy, but there are certain things we can work together on the Republican side. We had a hearing on the Emergency Powers Act, and we have a lot of agreement there on a possible statute. And the Republicans are just as much concerned about an overreaching executive, if it's maybe a different party, but in general, their philosophy is that. And so we might find some common ground. I hope you'd help us with that. I'm concerned what could happen with these pardons. I think somebody said that these acts of obstruction of justice were in clear public view. That's what maybe Mueller said. They were all in public view, which would have been the Comey thing. And but it wasn't all in public view because the dinner wasn't in public view when he had the one-on-one dinner and asked him to lay off of Mr. Flynn. We don't know what else was not in public view. It was in public view, I guess, when he told Lester Holt, I did it because of the Russia thing. But this president is a president who thinks he can get away with shooting somebody on Fifth Avenue. If he thinks he can get away with shooting somebody on Fifth Avenue, he's not going to have a problem in public view going, I did this because of the Russia thing. He also doesn't think about the ramifications of his actions because he's not real good on the second and third steps. Not real good on that. So I think the pardon power is something we need to look at. I think it can be abused. I think it will be abused. And the whole idea, and I'm so happy that Ms. Johnson got out of jail, my constituent, and the gentleman in Nashville got out. But there are thousands and thousands of people who Kim Kardashian has not taken to her heart, and that Sylvester Stallone hasn't read about. people who may not be dandies, who deserve commutations. And the idea that we give them on celebrity, and that he's asked for a list of people who are celebrities, not asked for people who have been unjustly convicted or served too long. He hadn't even thought about that. He's just looking for celebrities. So it's a problem. Mr. Raskin, you want to follow up with something? Professor Raskin.
Mr. Chairman, I want to thank you for calling this hearing, and I want to thank everybody for their flexibility and suppleness in dealing with the questions today. Obviously, we are in the middle of an ongoing constitutional emergency here, and we appreciate all of the support and the insight of the people in academia. Thank you, Mr. Chairman. I yield back to you.
Thank you. And that will conclude our hearing. And I have to find the last things I need to say. That concludes. We appreciate that. We've done that. We've done that. We've done that. This concludes today's hearing. I want to thank all of our witnesses for appearing today, even if they weren't under oral God's witnessed oath. Without objection, all members have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. With that excellent hearing, thank you for your participation. Excellent children in attendance. We're adjourned.